So today we're going to look at Brown versus the Board of Education in Topeka. Looking at page 412. Brown v. Board of Education Topeka 1 and 2. Board of Education means the town board of education that control the schools in that township area. Since the Supreme Court's decision in Plessy versus Ferguson, the doctrine, the idea of separate but equals, legalized racial segregation in the United States. So Plessy versus Ferguson made it legal to separate black and white people. The Supreme Court rejected that idea in 1954, which is what we're looking at today, the Brown versus Board of Education Topeka. Now, Mr. Brown, black person, he lived in a mainly white area in the city, in Topeka, and he wanted his daughter to go to the white school because it was close to the house. He didn't think it was fair that his daughter had to travel all the way across the town to the other side of the town to go to the black school when there was a white school very close to his house. So he wanted his daughter to go to the white school. The school said no. The town government said no. And so they go to court, and the court said no. And so they appeal. They go to the higher court, and the state court said no. So they appeal it up to the district and to the circuit court, and they also said no. So finally, this went to the Supreme Court, and that's what we're looking at today, the decision of the Supreme Court. Remember, when the Supreme Court makes a decision, they write down the reasons very carefully why they make that decision. So Brown versus Board of Education Topeka, May 17, 1954. This is the decision day. Segregation of white and Negro children in the public schools of a state solely on the basis of race, pursuant to state laws permitting or requiring such segregation, denies to Negro children the equal protection of the laws guaranteed by the 14th Amendment. So this said separation, segregation of children just because of their race, just because they are white or Negro, African American. Whether it is allowed by the state or required by the state does not give them the equality that is promised by the 14th Amendment. Do you remember in Plessy versus Ferguson, they also think about the 13th and the 14th Amendment. And they said the 13th and the 14th Amendment does not mean that you cannot separate. The judges in the court case, Plessy versus Ferguson, said the 14th Amendment was about political equality, about being a citizen, not about social equality, living together in society. This court case says that that is wrong. Even though the physical facilities and other tangible physical factors of white and Negro schools may be equal. So they said even though there may be one school, equal number of schools, even though there may be equal number of chairs and tables, this does not mean it is really equal. The history of the 14th Amendment is inconclusive as to its intended effect on public education. So it's not clear. Inconclusive means not clear what it was supposed to do for education. The question presented in these cases must be determined not on the basis of conditions existing when the 14th Amendment was adopted, but in the light of the full development of public education in its present place in American life throughout the nation. So it said we should not think about how life was in 1968 when the 14th Amendment was made, but we should look at how education is today. Where a state has undertaken to provide an opportunity for an education in its public schools, Such an opportunity is a right which must be made available to all on equal terms. If the state is providing education for its citizens, then that education must be equal. If the state is providing the education, then the education must be equal. Segregation of children in public schools solely on the basis of race deprives children of the minority group of equal educational opportunities. If you separate because of their race, the minority, the African American, does not have equal educational opportunities. Even though the physical facilities and other tangible factors may be equal, even though there may be an equal number of schools and other physical things may be equal, the actual opportunity is not equal. Here, tangible is always mean physical. So the physical things may be equal, but the opportunity is not equal. The separate but equal doctrine adopted in Plessy v. Ferguson has no place in the field of public education. So separate but equal, which is what the judges said in Plessy v. Ferguson, should not be used in education. The cases are restored to the docket for further argument on specified questions relating to the form of the decrees. So he said later we will talk about this again. Later we will hear more argument about specific detail. So here, this case is looking at the big idea: should schools be separated black and white or not? Later they will think more about the detail. But now, they are just talking about the big idea, should it be equal or not. Mr. Chief Justice Warren. Now, justice always means a judge. Chief Justice means the top judge. So in your Supreme Court, you have 9 judges. But there will always be a chairman, the senior judge. So you have 9 Supreme Court judges, but one of them will be the chief judge. The one that is in the middle, the one that is deciding. They will vote, but he will have the final decision. If 4 people say yes and 4 people say no, the chief judge will make that final decision. He is the number 1. So Mr. Chief Justice Warren delivered the opinion of the court. He is the one that has given this opinion. These cases come to us from the states of Kansas, South Carolina, Virginia, and Delaware. So there is more than one case. We focus a lot on Mr. Brown, but there were several other places where people are arguing for black people to go to the white school. And when it went to the Supreme Court, they combined all of the cases together. So their decision is not just for Mr. Brown, but their decision is for all cases. They are premised on different facts and different local conditions. So each one has a different local factor. There's a different reason in each place. But a common legal question justifies their consideration together. But there is one basic issue. And the basic issue is, should black and white be separated? Is separate but equal legal or not? That is the basic idea that all of the cases are focused on. In each of the cases, minors means children of the Negro, the African American race, through their legal representatives, seek the aid, the help of the courts in obtaining admission to public schools of their community on a non-segregated basis. So the African American children are wanting access to mixed schools. Non-segregated, mixed. In each instance, in each case, they had been denied admission to the schools attended by white children under laws requiring or permitting segregation according to the race. So in each of these places, Kansas, South Carolina, Virginia, Delaware, in each of these cases, the black children have been told, no, you may not go to the white school. the states either permit, allow, or require, insist on separate schools. And so the schools had said, no, your black children cannot come to these white schools. The segregation was alleged, something means to claim something, to deprive the plaintiffs of the equal protection of the law under the 14th Amendment. The plaintiff is the person asking. The plaintiff is the person going to the court to ask something. And it says the black people had been deprived. They had not been able to get equal protection, which is their right under the 14th Amendment. In each of the cases, other than Delaware, so in Kansas, South Carolina, and Virginia, a 3-judge federal district court denied relief to the plaintiffs on the so-called separate but equal doctrine announced by this court in Plessy v. Ferguson. This court means Supreme Court. It doesn't mean these judges in 1954. It means the judges back in the 1890s, Plessy v. Ferguson. But they refer to it as this court because it means from the Supreme Court. And they were both Supreme Court. And the district court is the appeal court. So they'd gone from the town up, they'd appealed, and they got to the district court, the federal district court. And the federal district court had said, no, you are not allowed to go to the school because Plessy v. Ferguson said separate but equal is legal. Under that doctrine, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities may be separate. So under Plessy v. Ferguson, if there is substantially, more or less, equal provision, so a black school and a white school, that more or less have the same facilities, that was legal. The plaintiffs contend, they argue, that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the law. The black parents and the lawyers for the black parents are saying separate cannot be equal. In the instant cases, there are findings below that the Negro and white schools involved have been equalized or are being equalized with respect to buildings, curricula, qualifications, and salaries of the teachers and other tangible factors. So they said the black school and the white school, the court in the city and the district court compare the schools. They said both schools have the same facilities, maybe tables, classrooms. Both schools have the same curriculum. Both schools have teachers with the same qualifications. They are all from university. Both schools are paying the teachers the same salary. So the black teacher and the white teacher, they're getting the same salary. They both have the same qualifications. They're using the same curriculum. So the lower court said these are equal. Our decision, therefore, cannot turn on merely a comparison of these tangible physical factors in the Negro and the white schools involved in each of the cases. We must look instead to the effect of segregation itself on public education. So it said, we're not going to look at the physical things, we're going to look at the effect. What happens if you separate black and white children? That's what the judge is saying. What is the effect on the children? What happens to them in the future if you separate them? In approaching this problem, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. So he says we cannot just think about the past. We can not only think about the 19th century when the 14th Amendment was made and Plessy v. Ferguson went to court. We must consider public education in the light of its full development and present place in American life throughout the nation. We must think about what is the situation today. What is the educational situation today in the country of America, in the nation of America. Only in this way can it be determined if segregation in public schools deprives these plaintiffs of equal protection of the law. Only by looking at the situation today can we decide if they have equality or not. Today, education is perhaps the most important function of state and local governments. It's very important. It is a big job that the state and the local governments do. Compulsory school attendance laws are the great expenditures for education. Both demonstrate our recognition of the importance of education to our democratic society. There are two things that show how important education is. Number one, education is compulsory. Every child must go to school. This is the law in America, not like Myanmar. In America, from the early 1910, remember the reform movement, when they started to look at the working conditions in factories, they made the law to protect the children. They must go to school. They're not allowed to work. And secondly, the government spends a lot of money, great expenditure, on education. So because education is compulsory, and because the government spends so much on education, it is clear that education is very important to America. It is required in the performance of our most basic public responsibilities, even service in the armed forces. You need education in what you do. Even if you want to be a soldier, you need to be educated. You cannot join the army if you cannot read and write. You need to have education before you join the army. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. This is what education does. Education helps people to be good citizens. Education helps them to learn cultural values. Education prepares them for later professional training, to get a job, and to be a good part of the environment, to be a good part of the community. In these days, it is doubtful that any child may reasonably be expected to succeed in life if he is denied the opportunity of an education. No child can be successful when they grow up if they do not have a good education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. The government, the state, is providing the education. This is a human right. To have an education is a human right. So, because it is a human right, it must be given to everybody equally. Yeah? Now remember, Plessy versus Ferguson said Amendment 14 is about political equality, the rights of a citizen, not making people socially equal in their community. Here, the judge is very carefully explaining that an education is not about being social. An education is a human right. And so, very carefully, this paragraph is very carefully explained that education is a human right. So he's showing that it is a political right. Human rights, political rights. And you can see how he's going to connect this to the 14th Amendment. The 14th Amendment is that everybody is a citizen and guaranteed equal protection under the law. So a right is guaranteed to everybody equally under the law. So you can see the argument, how the argument is building up so that the court can say the school cannot be separated. Because already they say this is a human right, not just about being friends, not just about being social. So we come to the question presented. Does segregation of children in public schools solely on the basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of educational opportunities? They say the question again, yes? This is the question that they are deciding in the court. If we separate children just on the basis of their race, just the white from the African American, does this take away the children's equal educational opportunity? And the answer, we believe that it does. The court is saying, if you separate children because of their skin color, you take away their equal opportunity to education. No? No. The next paragraph is going to talk about some of the other cases that have been in the court. Every time you see these words in italics and you see one name, one name, this is a court case. Okay? So, in Sweet versus Painter Supra, in finding that a segregated law school for Negroes could not provide them equal opportunities, this court relied in large part on those qualities which are incapable of objective measurement, but which make for greatness in a law school. So they're saying there was a court case, Sweat versus Painter, and in this court case, it was about a law school where you go to learn law to become a lawyer. And they said, if you separate black and white, you take away their equal opportunity. Because it's saying there is more than physical things. It's more than having the same number of classrooms. It's more than having the same number of textbooks. There's something greater. When you go to school, there are things that cannot be measured. Yeah? Qualities incapable of objective measurement. So we can count the number of textbooks, we can count the number of classrooms. These we can qualify. But there are other things that we cannot qualify. For example, the reputation of a school. If you graduate, let's say for example, you graduate from Mimoho, MHEP. When you apply for a scholarship and you have the MHEP name, people will look at your scholarship differently to if you have a certificate from a school that they don't know. The reputation of a school gives you opportunities later in life, but you cannot measure the reputation of a school. You will meet people in school, and later you might be able to work together, but you cannot measure the chances for working together in the future. So there are things that you cannot measure that are about your equal opportunity to education. In McLaurin versus Oklahoma, the court, in requiring that a Negro admitted to a white graduate school be treated like all the other students, again resorted to intangible considerations. So there was another case in Oklahoma. McLaurin wanted to go to a white graduate school. Graduate is post-degree. So you get your bachelor degree, and then you go to a higher degree, a master's or a PhD. This is graduate school. So the court case in Oklahoma said you need to treat the Negro and the white student the same. Why? His ability to study, to engage in discussions and exchange views with other students, and in general to learn his profession. These are things that you cannot measure. You cannot measure the value of having a discussion. You cannot measure the value of talking to other people and exchanging ideas. If you limit based on black or white, you take away their opportunity to share ideas and to learn. You cannot count it. It is intangible. It's not physical, but it is an opportunity that you are taking away from the black person if you separate them. Such considerations apply with added force to children in grade and high school. So these same ideas for university are even more important for high school. Added force means even more important. So the same ideas that people have used for university are even more important for children going to school in high school. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in that community that may affect their hearts and minds in a way unlikely ever to be undone. This sentence comes up quite often. This is the key, if you like, to the whole of it. This is the summary of the whole of it. To separate the black from the white just because they are black or white can make them feel inferior. You can affect their mind. You can affect their heart. You can make them feel lower, inferior, like they have a lower position in their community. And it says this cannot be undone. Unlikely ever to be undone means for the rest of their lives, they might feel like they are lower people because you separated them based on their skin color. So if I had to guess anything from the whole passage that might be in your exam, I would guess that that sentence might be there. So it's the key. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. You are taking away their right to equal education. Therefore, he's saying this is going to break the 14th Amendment. The effect of this separation on their educational opportunities was well stated by a finding in the Kansas case by a court which nevertheless felt compelled to rule against the Negro plaintiffs. So it said even in Kansas, the court agreed that the Negro child might not get equal opportunity later in life. But the court in Kansas still refused to allow them to go to the white school. Segregation of white and colored children in public schools has a detrimental effect upon colored children. Detrimental means negative. So separating black and white children has a negative effect on the black children. The impact is greater when it has the sanction of the law. For the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. He said the impact is greater, the effect is greater when the law allows it to happen. Because the law allowing it to happen shows that the government agree with this. And it normally leads, or it's normally interpreted or understood to mean that the Negro group, the African American group, is inferior, is lower. So it's like the African Americans feel the law is showing they are lower than the white people, and this will be with them for the rest of their lives, so they will not have equal opportunity. A sense of inferiority affects the motivation of a child to learn. If they feel lower, then they have less reason to learn. They have less motivation to learn. Segregation with the sanction of law, with the permission of law, therefore, has a tendency to retard, to reduce or to lower the educational and mental development of the Negro children. So if the law allows this, then the effect will be the educational development is weaker or lower or less in the African American children, and deprive them of some of the benefits they would receive in a racially integrated school system. You are taking away, you are depriving, you are taking away the benefit that they would get if the schools were racially mixed or integrated. Whatever may have been the extent of the psychological knowledge at the time of Plessy versus Ferguson, this finding is amply supported by modern authority. In the past, maybe the judges did not understand the brain well. They didn't understand how the brain develops, the psychological development of the brain. But today, we have more knowledge. Today, we have more understanding, more research that explains about the development of the brain. Any language in Plessy versus Ferguson, contrary to this finding, is rejected. Anything that Plessy versus Ferguson said in the past that does not agree with what we say today is now rejected. So the Supreme Court is saying you cannot use Plessy versus Ferguson anymore to give a reason for separation. We reject today. We conclude that in the field of public education, the doctrine of separate but equal has no place. So in education, you cannot say separate but equal. Separate educational facilities are inherently unequal. This also comes up quite often. Separate but educational facilities are inherently unequal. Inherently means by definition. Just because they are separate means they are not equal. So if you separate because of skin color, you cannot say they are equal. They are always unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the educational protection of the laws guaranteed by the 14th Amendment. This says that anybody who is stopped from going to a mixed school has their rights taken away from them. Their right to an equal education, which is guaranteed by the 14th Amendment, is being taken away from them. This deposition makes unnecessary any discussion whether segregation also violates the due process clause of the 14th Amendment. So we don't need to talk about the other information in the 14th Amendment. Quite simply, because they are separate, their right has been broken, so that is the end of the discussion. Their rights have been broken. Because these are class actions, that means group actions, not just for one, but a whole group of people. Because of the wide applicability of this decision and because of the great variety of local conditions, the formulation of decrees in these cases presents problems of considerable complexity. Because every situation is different, because every community is different, how we go forward is very complicated. On re-argument, the consideration of appropriate relief was necessarily subordinated to the primary question. So, is it how we go forward, how we give relief, how we solve this is subordinate, is lower than the main question of is it separate but equal okay or not. So they're saying that this so far has answered the primary question only. Is separate but equal legal? And the answer of the court is no. Separate but equal is inherently unequal. It will always be unequal. But what we do next is not clear. The constitutionality of segregation in public education is what they have decided. It is not constitutional. It is unconstitutional to separate people because of their race. We have now announced that such segregation is a denial of the equal protection of the law. In order that we may have the full assistance of the parties in formulating decrees means instructions, the cases will be restored to the docket, to the program. So it says, in order to make instructions for what happens next, the case needs to come back to us again later. We need more time to think about it, so you need to come back again after we have more time, and then we will give a decree. Then we will give an instruction for what must happen. So, of course, this is legal language. It is difficult to understand. But you're not going to get the whole of this in your exam. You would get about one paragraph. So those two bits that I showed you, are the two bits most likely to be in the exam. You could also get anything that talks about Plessy versus Ferguson could also be in your exam, because it might compare. You might get a paragraph from Plessy versus Ferguson and a paragraph from this, and you might be asked to compare why did they come to different conclusions, and you have to look at the language. So for example, where it says the psychological knowledge at the time of Plessy versus Ferguson was limited and now we have more knowledge, it might say that education or research has continued, and so people at the time of Brown have more knowledge about the development of the brain. That might be an answer that you had to choose. And of course, there would be 3 other wrong answers. Now, looking at page 415, it says Brown versus the Education 2, May 31, 1955. Remember, the first one was from May 17, 1954. Now, why have we got 1 and 2? Well, because at the end of number 1, it just said we need to think more before we give a decree. It's very complicated. Every local situation is different. So we need more time to think before we give any decrees. The first one is dealing with the big question: is it legal, is it constitutional to separate black and white children in education? And the conclusion that they reached was no, it is not equal, it breaks the 14th Amendment. But they did not go any further. Now in 1955, they're going to go further. Mr. Chief Justice Warren delivered the opinion of the court. So again, this is Chief Justice Warren explaining the decision of the court 1 year later. These cases were decided on May 17, 1954. The opinions of that date declaring the fundamental principle that racial discrimination in public education is unconstitutional are incorporated herein by reference. So we already recognize that we made a decision last year that it is not constitutional to separate black and white children. That is already decided. They are not going to explain that again. We say that by reference, meaning you can go and look at last year's decision and you can see the reason for that. This is accepted now. All provisions of federal, state, or local law requiring or permitting such discrimination must yield to this principle. All federal law, all state law, all local law that requires or allows separation must yield, must give in to this new idea that separate is not equal, that it is not legal. So they say all laws that are made by governments from federal to the city, from federal to local, must now recognize the decision of this court. There remains for consideration the manner in which relief is to be accorded. How do we give help? How do we give relief? Relief means help. Full implementation of these constitutional principles may require solution of varied local school problems. So to fully implement, to fully do what we said, there will be different answers in different places. School authorities have the primary responsibility for elucidating, assessing, and solving these problems. School authorities, school leaders, school board, have the primary responsibility for finding these questions, right? Saying what the question is, for assessing the question, and solving the question. Courts will have to consider whether the action of the school authorities constitutes good faith implementation of the governing constitutional principles. So the school can decide how they mix together. The court is not going to say how the school mix together, how the school choose new students. That will not be the decision of the court. That will be the decision of the school. The court will decide whether the schools act in good faith. Now, to act in good faith means to follow the meaning of the law, not just the letter of the law. So, for example, when the 15th Amendment said black people have the right to vote, and the southern states said, okay, but first you take a literature test, they were not acting in good faith. They were following the letter of the law, what the law said exactly, but they were not following the meaning of the law. The meaning of the law was that everybody have equal right to vote. But the law actually said you cannot use colour of skin to stop people voting. So the southern states said, okay, take a reading exam, knowing that black people are less likely to pass the reading exam. So they didn't follow the meaning of the law, they only followed the words of the law. They were not in good faith. Because of their proximity to local conditions and the possible need for further hearings, the court which originally heard these cases can best perform this judicial appraisal. So, because they are close, the local court is the best court to decide if the school is acting fairly or not. So they're saying the Supreme Court should not be deciding every school. The local court in every town should decide if the court is acting fair, if the school is acting fairly or not. Accordingly, we believe it appropriate to remand the cases to those courts. So to remand means to send back. So the cases like Brown versus the Board of Education, the cases in Kansas, South Carolina, Virginia, and Delaware, these cases will now go back to the courts where they began. But the courts have to remember that the Supreme Court has said you cannot separate because of the colour of your skin. So the Supreme Court give the big instruction, the local court can now do the detail. In fashioning and effectuating the decrees, so fashioning means making, effectuating means putting into practice, the decrees, the decisions, the courts will be guided by equitable principles. They must be guided by the idea, by the principle of equality. Traditionally, equity has been characterized by a practical flexibility in shaping its remedies and by a facility for adjusting and reconciling public and private needs. These cases call for exercise of these traditional attributes of equity of power. So it says we should look at how we have equal power, how we use equality for the people. These cases call for the exercise of these traditional attributes of equality. At stake is the personal interest of the plaintiffs in admission to public schools as soon as practicable on a non-discriminatory basis. The black children want to go to a non-segregated, to a mixed school as soon as possible, as soon as it is practicable. To effectuate, to enable this interest may call for the elimination of a variety of obstacles in making the transition to the school systems operated in accordance with the constitutional principles set forth in our May 17, 1954 decision. There may be rules in the school that need to be cancelled. They may talk about which area you are from, meaning only people from the white area can come. There may be rules about parents' jobs that need to be cancelled, because the black people would have low quality job, the white people would have high quality job. The judge, the court, is saying whatever local rules stop black children from going to a mixed school must be cancelled. Children have the right to go to a mixed school. Courts of equity may properly take into account the public interest in the elimination of such obstacles in a systematic and effective manner. The court, looking for equality, needs to check that the schools are really helping black children to go to mixed schools. But it should go without saying that the vitality of these constitutional principles cannot be allowed to yield simply because of disagreement with them. Just because the school leader do not agree does not mean you can continue to separate black and white children. Just because the town leader or the mayor does not agree does not mean you can continue. The judge has said the 14th Amendment gives equal opportunity to education, therefore you must do it. That's what the court is saying. You must do it. There is no reason that you can stop black children going to white school. While giving weight to these public and private considerations, the courts will require that the defendants make a prompt and reasonable start to full compliance with our ruling. Prompt means quick. So a quick start. The schools must quickly find a way for the black children to go to their school. Now look at your timeline. 1956 in Littlehampton in Arkansas. 1 year later, black children were still not allowed to go to the white school. What happened? The federal court and the federal government sent soldiers to help the black children to go to the white school. Because, as happened throughout history with the 13th, 14th, 15th Amendment, the white leaders were still trying to find obstacles, still trying to find reasons to stop the black children going to the white school. But the judge has said, this must happen as soon as possible. You must allow the black children to go to mixed schools. Once such a start has been made, the courts may find that additional time is necessary to carry out the ruling in an effective manner. So once you start, okay, you might need more time. The burden rests upon the defendants to establish that such time is necessary and consistent with good faith compliance at the earliest practical date. If the school says they need more time, the school is going to be the defendant. The school is the one that is going to have to explain in court why they need more time. And they will have to prove that they are not trying to break the 14th Amendment. They will have to prove that they are not trying to slow down the black children going to the white school. The proof will be with the school, not with the black family anymore. Because the Supreme Court has made the decision that the black children must go to the white school. So if they are stopped, if the school says we need more time, the school will have to go to court and explain why they need more time. And the court will decide, is it fair or not to make the black children wait? Like in 1956, the court said, no, this is too long. Too long, you need to stop this now. You need to allow the black children in. We will send the soldiers to make sure that the black children go to school. To that end, the courts may consider problems related to the administration arising from the physical condition of the school plant, to the school transportation system. So, for example, if you do not have enough classroom space, then you might need to build some more classes. If you do not have enough buses, school transportation, then you might need to find some more buses to go to the black area as well as to the white area. Personnel, you might need more teachers, revision of school districts and attendance areas into compact units to achieve a system of determining admission to public school on a non-racial basis. So each town is divided into small areas, and the people in those areas go to that school. It's called a school district. Like in Pa'an, you have high school 1, 2, 3, 4. I don't know if it works like that in Myanmar, but you cannot just choose which school you're going to go to. There will be a school district. There will be a line drawn around an area in a town. And the people in this area go to this school. And they're saying that the education board in each town might need to change the district. They might need to redraw the boundary so that there is black and white mixed together. They will also consider the adequacy of any plans the defendants may propose to meet these problems and to effectuate a transition to racially non-discriminated school system. If the school says, we are planning to do it, we make this plan, this plan, this plan, the court will decide if the plan is enough or if they need to do more. So the decision of if they have done enough or not will be up to the court. But the goal, the aim, is a non-discriminatory, racially mixed school system. During this period of transition means change, the courts will retain jurisdiction of these cases. The court will decide if the school is moving quickly or not, if the school is changing quickly or not. The local court. But if the local court does not do, then again, where will the decision go? Back up to the higher federal court, circuit court, district court, Supreme Court. So the Supreme Court is saying, we know that every situation is different, so we want every school area, every local area to make their own plans. We're not going to make the rule for everybody. The local area can make the rule, and the local court can decide if they do enough or not. But if they are going slowly, the school is responsible for explaining why they are going slowly, and the court can order them to go more quickly.